Welcome to the Sacramento County Child Protective Services Policy and Procedure Training on the notification of pending parole, otherwise known as Dustin's Law. The history of Dustin's Law. In 1988, 4-year-old Dustin's father was on parole after serving time for child abuse against his eldest son. On November 23, 1998, after refusing to pick up his toys, Dustin was murdered by his father. Dustin's grandfather led the effort to pass Senate Bill 1343, which is also known as Dustin's Law. The law was designed to protect children from convicted abusers by notifying immediate family members and county child welfare services of an offender's upcoming release from prison. The purpose of this policy and procedure is to discuss when child welfare agencies can request notification prior to release on parole of individuals incarcerated for crimes related to child abuse. In addition, this policy will describe how to request notice, the notice and response timelines when corresponding with the incarcerated person's place of confinement, and revocation of notification at the conclusion of the juvenile dependency reunification case. Under California law, including Senate Bill 1343, which is also known as Dustin's Law, county child welfare agencies providing reunification services to families are entitled to receive notification when an incarcerated parent is pending release on parole for any of the following applicable offenses: Penal Code Section 273A, which is child endangerment and related offenses; PC 273AB, child assault likely to result in great bodily injury or death; PC 273D, child abuse including cruel and inhumane corporal punishment; any sex offense identified in statute as being perpetrated against a minor; and any act of domestic violence. Following the request for notification of pending parole, the social worker is allowed to submit comments directly to the prison where the individual is being held regarding potential safety threats related to the individual's re-entry into the community. These comments remain part of the individual's permanent parole file. Here are some welfare and institution codes and penal codes that will be used throughout this training, which are important for you to be comfortable with. The Welfare and Institutions Code 16507D, which describes the requirements for child welfare agencies when requesting notification prior to the release of an inmate who is convicted for any of the following offenses: PC 273A, 273AB, 273D, any sex offense being perpetrated against a minor, or any act of domestic violence. To be eligible for notification, the child welfare agency must be providing reunification services to one parent, and the other parent must be serving a prison term for any of the above described offenses or acts. Penal Code 3058.4 describes the obligation of parole officers to report to child protective agencies if a person paroled violates parole conditions related to restrictions on child-family contact following convictions of the above code sections. Penal Code 3058.65. This describes the requirements and timelines for the Department of Corrections to provide county child welfare agencies an immediate family notification that a person is scheduled to be released on parole or re-released following a period of confinement pursuant to a parole revocation without a new commitment. Our policy states that within 7 days of confirming an individual associated with an open juvenile dependency reunification case is an incarcerated parent, for any of the offenses that I listed in the previous slide, the social worker shall submit a written request for notice as described in the procedure section, which we will get to shortly. Please note, WIC Section 16507D offenses include the PC Sections 273A, A, B, and D that I listed in the previous slide, any sex offense against a minor, and any domestic violence offenses. If parole occurred prior to the assigned social worker becoming aware the parent was incarcerated for crimes described by this policy, the assigned social worker shall initiate and maintain regular contact with the individual's assigned parole officer during the reunification services portion of the dependency case to address any potential safety threats, including, but not limited to, parole term violations, the threat of harm to a child previously victimized by the paroled individual, and the threat of harm to any child residing in the same household as the paroled individual. Following termination of the reunification portion of a dependency case, requests for notice will be formally rescinded via a second written contact, as described in the procedure section. Please note, the custodial parent of the potentially at-risk child and/or the incarcerated person's spouse may request and are eligible for notice at any time by state law via the State Office of Victim Services. Requesting notice. This procedure will typically occur in the course of court services due diligence in locating absent parents, to include those who may be incarcerated. In the event the information is not initially known or becomes known at a later point in the dependency case, the assigned social worker, regardless of the program, shall request notice of release prior to parole by completing the following bulleted tasks. The assigned social worker will write a letter to the incarcerated person's place of confinement requesting notice of release prior to parole to include the following information: the name, role, and contact information for the social worker requesting notice, the incarcerated parent's name, date of birth, and the California Department of Corrections number, which may be obtained via the California Department of Correction and Rehabilitation's website, reference to PC 3058.65, which allows for the assigned child welfare social worker to receive notice regarding an incarcerated parent assigned to their caseload, pending parole following convictions for any of the crimes related to Destin's Law, as described in WIC 16507D. The social worker should receive correspondence from the state prison where the incarcerated person is housed acknowledging the social worker's right to notice, which shall occur via mail at least 60 days prior to the scheduled release or no later than 24 hours following a final decision regarding an immediate or unscheduled release. Social workers should submit written comments to the State Prison Records Department when applicable to indicate possible safety threats or concerns should the individual be paroled. These written comments should be within the following timelines: no less than 30 days prior to the scheduled release, with a return response from the State Facilities Records Department no less than 15 days prior to the scheduled release. Or, in the event the original notice is less than 60 days prior to the release, written comments will be submitted as soon as possible. Consider scheduled release date and impact of information. Please note, if written comments are submitted less than 30 days prior to the scheduled release, the state's Facility Records Department is required to respond as soon as able prior to the scheduled release. Rescinding notice. Once the juvenile dependency case is no longer in the reunification stage, the assigned social worker shall submit a second letter mirroring the information included when requesting notice to indicate notice is no longer required per WIC 16507D. Here is a template letter of the notification of pending parole requesting or rescinding notice. There is also an example of this template letter in Policy Tech, as well as attached to the training in MyLearning. If you have further questions, you can find the most updated policy in Policy Tech. Please email CPS Policy and Procedure at statcounty.net and include notification of pending parole in the subject line. Thank you so much and have a great day.